Welcome back to Big Law University. This is Big Law University presents Searches and Seizures Part 2, where we're discussing property, technology, your body, and your freedom. So, if you watch Part 1, good job. Pat yourself on the back. That means you already have an understanding of what the reasonable expectation of privacy is. Again, this is the main test that courts use to decide if a search happened. But here's what most people, including a lot of law students, don't fully appreciate. And that is that there is a second way that the government can conduct an illegal search. One that doesn't really care about what you expect. One that goes back, all the way back to the founding of this very country. One rooted in something as old as property law itself. And on top of that, we're getting into seizures today. So not just your belongings, but you, your person, your freedom. This is the part of criminal procedure with some overlay of constitutional law where theory meets real life. So we're gonna go ahead and get right into that. So the property-based approach, the old school weapon. So in part 1, we focused on the dominant modern test, which is the reasonable expectation of privacy. But the Supreme Court has been dusting off something much older, something the founders themselves would have recognized. The property-based approach says this: a search occurs if the government trespasses, it's a key word, trespasses onto, another key word, constitutionally protected area to obtain information. So burn that into your brain. A search occurs if the government trespasses onto a constitutionally protected area to obtain information. And what are those constitutionally protected areas? The Fourth Amendment tells us directly there are 4 categories. They are persons, houses, including your curtilage, papers, and effects. Effects is just a fancy word for your personal property. Think of it as your car. So in plain English, think of it like this. The founders didn't want king soldiers barging into your house and rifling through your belongings. The property-based approach is the same principle applied today. If the government physically touches or invades something that belongs to you, that's a search. Full stop. The GPS tracker, where the two tests collide. So this is the case that brought the property-based approach back to life. So pay very close attention if you're not. The government attaches a GPS tracker to your car without a warrant. They want to follow your movements. So under the privacy test approach, this is probably not going to be a search. You're driving on public roads. There's no reasonable expectation of privacy in your public movements. However, under the property test, this absolutely is a search. They physically attach a device to your car, which is again your effect, to obtain information. That is a trespass. That triggers the Fourth Amendment. So in plain English, you drive publicly, anyone can see your car on the road, but your car belongs to you, I would hope. The movement, the government physically touches your property to spy on you. So the moment that the government physically touches your property to spy on you, that is when they cross the line. It doesn't matter that you were in public. So monitoring devices on people. So the property test approach doesn't just apply to your car, it applies to you as well. So where the state required a convicted sex offender to wear a satellite-based monitoring device at all times, the Supreme Court said that itself is a search. Why? Because it's a physical trespass onto a person, one of the 4 protected categories to obtain information about their location. So in plain English, if they strap a tracking device to someone's ankle and follow their every move, you've probably intruded on their person to gather information. The Fourth Amendment has something to say about that. Chalking tires. Yeah, really. This one is going to surprise you, and it should. Parking enforcement officers chalk your tires to track how long your car has been parked. Seems harmless, right? A federal court said that itself is also a search under the property-based approach. The chalk makes physical contact with your car, which again is your effect. It's placed there to obtain information about how long you've been parked. Physically trespassing. So purpose of getting information, that's the test. That is the search. So in plain English, the moment a government official physically touches your property, even with chalk to gather information against you, they've triggered the Fourth Amendment. You didn't think chalk was constitutional law, did you? The dog sniff showdown. Public places versus your front porch. Now, remember from part 1, a drug sniffing dog in a public place, that is not a search. No reasonable expectation of privacy in smells floating in public air. Now, here's where it flips completely. Police officers bringing a drug sniffing dog onto your front porch, they're physically on your curtilage, the protected area around your home, to use the dog. The Supreme Court said that is a search. The physical intrusion onto the curtilage of a home for the purposes of gathering information triggers the Fourth Amendment under the property-based approach. So think about it like this in plain terms. Same dog, same nose, completely different result based on where it happened. Airport lobby, not a search. Your front porch, search. Location changes everything, and the property-based approach is the reason why. Electronic surveillance technology as a weapon. So here's where the Fourth Amendment has to evolve with the times. Technology can be used to invade your privacy just as effectively as a physical trespass, sometimes more effectively. The rule is if law enforcement uses sense-enhancing technology, especially technology not generally available to the public, to observe intimate details inside a home or other protected place without physically entering, that is a Fourth Amendment search. In Kylo, which is one of the cases, if you're in law school, you'll probably study, the government used a thermal imaging device pointed at a private home to detect heat signatures from marijuana grow lights inside. The court said you cannot use technology to see through walls and call it something other than a search. So if the government uses high-tech device that the average person doesn't have to directly look inside of your home without stepping foot in it, that's a search. You don't get to use a space-age tool to bypass the rules that apply to a physical intrusion. The tracking device and the container both test hitting at once. So sometimes situations trigger both the privacy approach and the property-based approach simultaneously. So law enforcement installs an electronic device inside a container. Criminal suspects buy that container and transport it to their private residence and a commercial storage locker. This is a search under both standards. Under the privacy approach, the suspects have a reasonable expectation of privacy in the location of their private residence. Tracking them there violates it. The property-based approach says that if law enforcement uses technology as a substitute for physically intruding into a constitutionally protected location, that is also a search. So you can't just hide a spy device in someone's property and follow it into their home. Not under any theory. Both the privacy test and the property test shut that down. Now we're gonna get into the good part regarding seizures. What does it mean to be seized? So we've been talking about searches. Now we're gonna flip to the other half of the Fourth Amendment, seizures. There are two kinds of Fourth Amendment seizures: seizures of persons and seizures of property. So we're gonna go ahead and break them both down. So seizures of persons. When is your freedom being restrained? Not every interaction that you've had with the cop is a seizure. This is important. The government can approach you, ask you questions, and they can even ask to see your ID, and that alone does not make it a seizure. The test is the reasonable person standard. A person is seized if, under the totality of the circumstances, governmental action communicates to a reasonable person that they are not free to terminate the encounter. This communication can be either verbal or non-verbal, direct or implied. In public, cops can approach you, ask questions, request ID, and ask to search your bag without it being a seizure, as long as a reasonable person would feel free to walk away. So in plain English, picture this. A cop walks up to you on the street and says, "Hey, you, can I talk to you?" You are free to say no and walk away. That is not a seizure. But if that same cop draws a weapon and tells you not to move, now we're talking about a seizure, because no reasonable person will feel free to leave. And when exactly does a seizure happen? So the Supreme Court has been very specific about this. A seizure of a person occurs in any of these scenarios. Scenario 1, an arrest. Anytime a governmental official successfully arrests a person with or without physical force, the arrest itself is the seizure. Scenario 2, physical surroundings. A governmental official deliberately physically restrains a person, hands on you. You're not going anywhere. Scenario 3, submission to a show of authority. No physical force at all, but the officer's show of authority is so compelling that you submit to it. That submission is the seizure. But here's a very critical rule. If you do not submit, there is no seizure. So if the officer draws his weapon, orders you to stop, and you run, no seizure occurred because you didn't submit to the authority. So here's the scenario. Cop points a gun at you and says freeze. You freeze, seizure. You bolt, no seizure. The Fourth Amendment protection only kicks in the moment you actually comply. It sounds harsh, but that's the law. Now, seizure of your property, when the government takes your stuff. This one is more straightforward. A seizure of property occurs whenever the government assumes possession and control of a person's property. But here's the critical exception: abandoned property. So there is no reasonable expectation of privacy in abandoned property. If you abandoned it, you can't complain that the government seized it. And this gets very practical when people are running from the police. If you're fleeing from police and you drop or discard something, that item is not the product of a seizure. You abandoned it. The police can pick it up freely. So you throw your backpack into the bushes while you're running from the cops. You just abandoned it. When the police grab it, they haven't seized anything in the Fourth Amendment sense. You gave it up the moment you threw it. Think before you toss. So let's go ahead and bring this home. Part 1 was about privacy. Part 2 was about property, technology, and freedom of movement. So here's the framework burned into your brain after today. 2 ways a search can happen: violation of a reasonable expectation of privacy and physical trespass onto persons, houses, papers, or effects. Two ways a seizure can happen: seizure of your person, so arrest, physical restraint, or submission to authority. And two, seizure of your property. Government takes possession and control. And two things that are not seizures: running from a show of authority, no submission, no seizure, or abandoning property. You dropped it, you don't own the problem anymore. So, for the law students, know which test the court is applying in every case. The GPS tracker in Jones was not a search under the privacy analysis, but it was under the property-based approach. That distinction is exam gold. For everyone else, the Fourth Amendment isn't just a courtroom concept. It's the legal boundary between your life and the government's power. Know where that line is. Now, next we're gonna get into warrants in the next video, when you need them, when you don't, and the exceptions that will make your head spin. Subscribe to Big Law University, like this video, share it with someone who thinks they already know their rights, because after watching this, they will realize that they didn't. Big Law University. Know the law, own the room.